calling yourself a capital raiser, I think you're already, I don't like that term. I've used it more now because people identify it's like a vernacular, but at the end of the day, if you're calling yourself a capital raiser and you don't have a license, you're just asking for problems, because just like a law, you can't practice law without a law license. You can't practice medicine without a medical license. It's almost like arguing. Here's the analogy I've come up with right lately. I say, look, you're somehow involved in some kind of, maybe it's something in the medical thing. Maybe you're talking about some natural cures or whatever. And they're like, hey, you need a license. You're not a doctor. You need a license. Like, no, I'm not a doctor. I'm not practicing medicine. But then you call yourself a doctor.
Yeah.
It's like, okay, well, dude, like if you're going to call yourself a doctor, then you're really going to have a hard time arguing that you don't need a medical license or you're not practicing medicine. It's the same thing with capital raising. Like you generally have to have a license unless there's an exemption, and there's only one exemption that works for us, and most people don't fit into that. So calling yourself a capital raiser, I'd be super, if you, like Peter, you are an operator, like you do raise capital, but that's one of the many functions that you do. You then acquire, you're underwriting, you're doing due diligence, you're finding a property, you're getting into contract, you're talking to lawyers, you're asset managing it, you're doing the business plan. I know you work with a lot of sort of, let's call it nicely, dilapidated things. Like you're really adding a lot of value, increasing the rent. Like you're doing so much work. Capital raising is a part of it, but it's not the primary role that you're doing. Exactly. And a lot of these co-GPs and a lot of the fund of funds, their primary role is raising money. And if on top of that, you're tying the compensation to how much you raise, that's transaction-based compensation. That's the hallmark of broker-dealer activity.
You're listening to the Accredited Investors Only podcast, presented by Accredited Life.
Mauricio, welcome to the show. How you feeling today?
Thanks for having me, Peter. Really looking forward to this.
Hey, as am I. So let's start with an introduction. Who are you? What are you doing? What's your story?
I'm a lawyer. Don't hold that against me though. I'm not your typical lawyer. In fact, my good friend Tom Wheelwright, which I think probably some of your listeners may know, he's a rich dad advisor, wrote a great book called Tax-Free Wealth. He likes to say I'm one of the few attorneys that actually speaks English. So I'm pretty good at taking these complicated legal matters, making them easy to understand. That's kind of like my superpower. And I've been doing this for a very long time, as you can tell from my gray hair. I've been practicing for now 26 years. I think I started work in 1999 as a litigation attorney. So I did a lot of securities work and in the litigation field back then. So I would represent, the Merrill Lynch's, American Expresses, Goldman Sachs, American Express, those kind of guys. But I would represent them when they got sued. So we had disgruntled people, they would get sued. So I would, respond. It was all motion pleadings, depositions, trial work, appellate work, arbitrations, like all that litigation stuff, which is whatever. It's not something that it's a lot of conflict, right? You're always fighting with the opposing counsel. So not something I really enjoyed doing, but I did that for about 6 or 7 years. Got super lucky, man. I came across that little purple book, which I'm sure you've read, and a lot of your audiences have read, Rich Dad, Poor Dad. And that really changed the whole direction and course of my life, professionally and personally, by the way. It's one of the stepping stones to meeting my wife ultimately. Wow. So really, really impactful book for me. But that really led me to a different path. So because of that book, I got introduced to a group called the Real Estate Guys, who had, they're big real estate developer guys, went to work in-house for them. And that's really where I cut my teeth in what I do today, which is syndications. And so I was their general counsel, oversaw everything. And back then the guys were raising a ton of money, but old school. This is like 2005, right? So imagine you raising money in 2005, you're talking physical locations, like we're meeting at this place, and there's chairs, and then you'd be in a room with 80 people in rows of chairs, everybody slammed in the room. There's a PowerPoint presentation. The guys are in the front of the room with their, suit and ties, looking like literally pitching a deal in real life. I'm there as the attorney, literally printing out, all the legal docs, right? All the private place memorandums and operating agreements. People are writing me checks, right? I mean, it's literally old school. So that's kind of where I cut my teeth about this thing, again, 19 years ago. I can't believe it's been that long, 20 years ago. And then at some point, I just decided to leave and start my own firm. So I founded Premier Law Group about 2006, so about 18 years ago, built that up to a multi-7-figure business, primarily representing GPs, right? So I did a lot of work helping them, making sure to, basically helping them stay compliant, raise capital in full compliance with federal and state securities laws. And then I recently, we were just talking about this before we come on, just recently exited and sold that firm to my amazing partner, Bethany LaFlamme, who had been with me for almost 10 years now. So she was basically running the show anyway. You know, it was almost like, what do you guys, you're kind of like, we don't need you here anymore, Mauricio, you can leave. Thank you. So, you know, so I've handed the reins over to Bethany and our amazing team over there, Jonathan and Ashley and Jen. And I did what I really have a passion for, which is teaching. So I started a mentorship program where I literally teach and mentor elite syndicators to basically raise capital compliantly. And we do that through Access. We do a weekly call. That way, all the information that syndicators are drowning on, we actually get to implement that in our calls, because you bring your specific, you know, your specific situation, your specific things, and you get to ask me specifically, hey, how does this apply to this particular rule? And we review a bunch of stuff. So that's been super fun. And like I said, just started that a few months ago. We're almost at 100 members now. So it's been a lot of fun.
That's amazing.
Yeah.
Well, that's an amazing journey right there. Yeah. And there's so many things we can unpack, but I guess I'll start with that. You know, it's you got to, over the last, I love what you're, like the picture you're painting with the seminar, you know, like that, we're at a hotel or something like that. I see those commercials on there's still, like in the Philadelphia area, it's called Crash Proof Retirement. And they have commercials on, and it's all the people lined up in the chairs on. You think, wow, people still do that and go to those things and all, but the internet's changed that drastically, right?
Big time. Yeah, big time. I mean, now most people, you know, even though now advertising is allowed and you can probably do stuff, mostly the internet is used for these communications and webinars, right? Most people now will do some sort of a webinar, so they'll have a deal. Even if they're not allowed to advertise it, they can send the information to people they have pre-existing relationships with, and so they'll invite them to a webinar, right? That's usually a good way to sell. It's like, hey, if you're interested, we've got you got a new deal. We're looking to raise $1 million. We're doing a webinar next Wednesday. Come join us. Come answer. We'll do a presentation. We can answer questions, and that's kind of one of the mechanisms we use. Not to mention this stuff, right? I mean, people can now Zoom calls instead of having to meet for coffee or for dinner if somebody's interested. In the old days, they'd literally pick up the phone, you talk on the phone, and they still probably wanted to meet one-on-one with you. So you'd have go grab coffee or lunch or something if it was serious. Today, you just do a Zoom call, right? And it's even if it's one-on-one, it's a Zoom call. So technology has changed things dramatically. I don't know anybody who does an actual physical presentation. We do physical meetups, right? That's a good way to meet people, a good way to extend your network. Going to real seminars, right? In-person seminars, but really meetups, just little local real estate meetups where you get 10, 20, 50, 80 people together. But time are really different. And I think back then, I think Robert, who's the main Robert Helms, he was still back then may have not even gone over to PowerPoint yet. I think he was doing the old acetates, which are you young kids, and you look pretty young, probably don't even know what those are. But it was basically a transparent film, film. You would put on a projector and write on the film, and that would project out into a thing. And that was before before PowerPoint or Keynote. But so a lot has changed, and I've seen it all. Right back in 2020, the internet was technically around, but not to the point it is today. And more importantly, the rules, back in 2000, after the financial crisis, right? Financial crisis, 2008, 2009, Congress responded in 2012 with something called the Jobs Act. And that really was meant to make it easier for people to raise money, because the financial system had kind of frozen up and nobody was lending, nobody was raising money. It was really tough to do anything. And so they loosened the rules quite a bit in the Jobs Act of 2012, which ultimately got implemented in 2013. But part of that implementation was this allowance, if that's the right word, for people to advertise their deals, which previously they could not do that. You had to go public, do an IPO, and do all that stuff. And they came up with a new rule in 2013 that said, hey, even though technically it's a private offering, this makes no sense, by the way, but even though technically this is a private offering, you're going to be able to advertise your deal to the masses with some restrictions, of course, and we can talk about what those are. But really, right around 2013, that rule came into place, and the internet. I mean, if you look back, all of these Facebook and Instagrams, and I mean, I think Instagram didn't even exist back then, but even Facebook and LinkedIn, they weren't what they are today. And over the last 10, 15 years, it really has exploded and really made syndication kind of a hot thing. And I've just been fortunate enough to kind of ride that wave.
Great timing, right? I tell this story a lot on the podcast, but I always think it's funny and goes right along with what you're saying. It was about 10 years ago, I went to one of these like kind of business think tank things. It was where I went to Temple University out of Philly, and I went there. I had this business idea, I was raising money at the time, and I thought, I can create this platform online where all these deals are on there. And I think Fundrise was a thing, SBRE funds, if you remember that, Matt Burke back in the day, was a thing. So I really wanted to play off of that. And the guy there, I think he was like, I think he was connected to Blackstone somehow. It was called Blackstone Launchpad. That was it. And he was like, that is the dumbest idea I've ever heard. That's not how this business gets done. It's a face-to-face handshake business. And my God, has the internet changed that over 10 years?
Yeah. Yeah, 100%. Oh, I still think it's a relationship business. A lot of one of the mistakes I think a lot of new people that are getting into this business, they think that, hey, if I get a deal under contract and I just start buying ads or just, flooding the Facebook and social media and doing all these acts, somehow that's going to help me raise money. I don't think that's true. Can you do that? Yes, I've seen instances where people who've never heard from me before will see an ad and sure they'll buy. But I think what social media has allowed people to do is really get their name out there. It's become easier to be known, right, to the masses, especially people who have huge followings. So it's a great mechanism to tell the world that you exist, tell the world what you do, what your specialty is. And in our world, we just know, like there's hundreds and hundreds of people that I feel like I know because we interact on social media and on things. It's still a thing, but I've never met them in my life. And in fact, it's pretty funny when we finally meet at an event. So I think you build the trust maybe, and because people invest with people know, like, and trust. So they feel like they know you on social media. They assume they like you. And then I think the trust comes from just the content people put out, demonstrating the knowledge of whatever your asset class is or what you're doing. Like, that's my case, right? I'm the same way. Like, I'm considered one of the premier syndication attorneys, but primarily it's because I'm speaking all the time on the circuit, but now I'm able to amplify, a speaking gig, maybe a couple hundred people see it. But if I now put some of those into clips and I put it on social and interact, now like hundreds, if not thousands or tens of thousands of people see that. Yeah. And it's just a great way to amplify what you're already doing. Yeah,
I love it. That's a great perspective. It's about the brand building and the thought leadership, authority leadership.
100%.
First, right? Well, so you must scroll social media, Facebook and LinkedIn, and just see people doing crazy stuff all the time.
Oh my goodness. Yeah.
Talk to me about that. You know what I mean? Like, what percentage do you think of people are just doing it like just rogue? They're not really following the attorneys, and I'm sure there's attorneys out there too where they don't maybe necessarily keep up with the rules and the laws and that kind of thing as well, right?
Yeah, so there's two great points. I'll do one at a time. So first of all, more people than you think are out there doing stuff they're not supposed to. And it's not because they're doing it on purpose. They just don't know what they don't know. Like, they don't know that this is going on and they're not supposed to do it. And when I was at the firm, I couldn't understand this because I would get questions, like even social media posts, and it's like, hey, they would ask me all these questions, right? And I would say, well, first of all, you're not one of my clients. So why aren't you asking why aren't you asking your attorney? They're like, why? This is a great question, but this is your attorney.
I don't have one.
And then it hit me, and it hit me like a ton of bricks. And that's exactly why I started what I'm doing, is that most people don't hire a specific securities attorney until the end of the process. They've already got the deal under contract, and they, basically they got the deal under contract. Then they say, hey, I need to go raise a bunch of money. Let me go hire a securities attorney to kind of draft the docs or do whatever. But in between that gap, right, where from the time you decide you're going to go raise a bunch of money, you're interested in this, maybe you go to some classes or webinar, this raising capital thing sounds like a good idea, or maybe you just finished up a raise and you're like, hey, my next raise is in 6 months. All that time frame, that window from that time to the time you actually hire the attorney to help you, there's a huge compliance gap. It's something I call the syndicator blind spot, because you're out there all alone, posting on social media, attending things, talking to people. We can talk about some of the big landlines, but you're sending stuff to investors, like spreadsheets and underwriting, and it's like nobody's looking over your shoulder. Right. So social media is a great example of that. People are posting, but they don't have anybody looking over their shoulder and say, yes, that's compliant. That's not compliant. You tweak this. Don't do that. Hey, your website's a little funky that you shouldn't, hey, you're not allowed to do that. They don't have anybody looking over the shoulder. And it's tough because most lawyers, if you're like, hey, I have a quick question, you can't just pick up the phone, call a law firm and say, hey, I only need you for 20 minutes or 30 minutes. Can I pay you for 30 minutes of your time? It doesn't work that way, right? Now, if you're a client of the firm and you're a big client, well, not a big client, but if you're a client of the firm and you have a question, that's fine. But if you don't have a relationship with the firm already, they're not just going to go all through all the administrative nonsense of getting you onboarded at, getting an engagement letter, getting a retainer. Like, it doesn't make sense to do it for 20, 30 minutes. So I get it. And so that's why having sort of this weekly access to me to be able to ask these questions, hey, here's a social media post that I wanted to post. Can I do that? Or, hey, I saw John's post. That didn't sound right. Is that legal or not legal? These are things that we can implement on our calls.
Yeah, that's gold. Is there any, before we dive too deep into, all this?
Peter, sorry to interrupt. You made the other point, which I actually have to make a video. I've got like 500 videos on my YouTube channel, but one of them that I feel like I've covered everything, but this is one topic that I haven't, and it comes up a lot, and I just assume everybody knows. But just because you're an attorney,
yeah,
right, doesn't mean you know anything about securities laws.
Yeah.
Like I know nothing about mergers and acquisitions, right? I'm not even a real estate attorney. Like I'm the last person you want looking at a purchase and sale agreement or pulling title or negotiating loan agreements. Like I don't know any of that stuff, right?
Yeah.
So it's important to understand that lawyers are similar to doctors, right? You have a primary care physician who kind of knows a little bit about everything. And then if you have a heart problem, hey, let's send you to the cardiologist. Oh, you have a knee problem, let's send you to the orthopedic. Oh, you're pregnant, let me take you to the OBGYN, right?
Yeah.
So lawyers is the same way. Everybody has a specialty unless you're sort of a general counsel. And so I get calls from attorneys all the time that don't specialize in securities laws. Say, hey, I have a client doing this. Maybe they're a business lawyer or a startup lawyer, and they're like, this doesn't sound right. This is security. Do they need to register? And they're literally asking me, and that's all great because if I had a question about a startup, a tech startup, I don't know anything about that, so I would call it a tech startup. So it's really important to be working with somebody who specializes in securities laws. Just like if you have a heart problem, you don't want to go to an orthopedic and a generalist. You want to go to a cardiologist.
Yeah, that's a great nugget there. And it was one of the reasons I brought it up because I've heard those stories where people kind of going to their real estate attorney for a fundraise or something like that. And it's just like, that's not the right person to go to.
Yeah. And I'll tell you a quick story because it kind of leads into some of these issues of just not knowing what you don't know. I have a friend of mine. Well, actually, I was visiting a friend of mine, and we were talking about an old friend who was in the hospitality business, and he created a new product. It was actually cool. It's like a wine product that gets done in a can or something. And my friend had invested some money into this deal. I think it was like, whatever, 25, 50 grand. And I was just kind of curious, like, I wonder how do they do it? How do they structure it? Was it what exemption? And it seemed clear that they didn't do any of that stuff. And so I reached out to them. And their answer to me was like, oh yeah, no, we ran, this is a startup. So we talked to a startup attorney. So he set everything up cool. And we're not advertising the deal. It's only friends and family. We're not advertising the deal. So we're good. And I'm like, no, you're not good. Like you've clearly violated securities laws, but they don't know. You just don't know what you don't know. And there's a lot of people out there doing stuff, not realizing that, they're actually selling securities. They think that whatever structure they're doing is because they're doing it a certain way. Somehow they're exempt and they're not.
Sure. Well, it leads perfectly into my next question was because I feel like it's important to kind of set the kind of the foundation first here so people realize why it's important.
Yeah.
They probably don't understand what the consequences are. You know what I mean?
Yeah.
So let's start with that. You know what I mean? What are the consequences? That should hook them in. And so that
here's a good hook for you. Here's a good if you want to get hooked in. I wrote a book several years ago, and I think I was going to update it, but now I'm going to just kind of restructure it. But I wrote a book called The 5 Things Every Syndicator Must Know to Stay Out of Jail.
Yeah,
that's your consequence, right? And if you want a copy of it, you can go to stayoutofjail.com. It's a good introductory ebook on securities laws or whatever. But clearly, you can go to jail. Now, it's unlikely. I don't want to come up like if you're doing. If you're acting in good faith, but Bernie Madoff, they're in jail. I mean, if you're defrauding investors, if you're doing something, if the SEC thinks you're defrauding people, you can go in jail. Now, most likely what usually happens though, the vast majority of the time, which is a pretty big consequence is that there's a rescission right, meaning no matter whether it was your fault or not, if the investor lost money, you're going to be obligated to return all of their money plus interest plus penalties, right? And usually if the deal's gone south, they don't have that. Either all the money was in the property and the property's gone and they don't have any personal assets, or certainly they don't have $2 or $3 million to cover the losses. So you end up filing for bankruptcy and you will be barred. There'll be a barring of raising capital depending on how much you negotiate with the SEC. Is that a lifetime ban? Is it a 5-year ban? So that's the more likely scenario. But think about it. If you don't follow securities laws, you are guaranteeing essentially the investor's return, because if they do well, they're going to win. If you lose their money, you have to return their money at plus interest, and the penalties go to the SEC, but they're going to get their money back plus interest, assuming you have it. So we don't want to be guaranteeing investments. I mean, if the investment goes wrong because of something that was outside of your control, like, a lot of people are having some issues now with what happened with interest rates going through the roof, or maybe even during COVID, you may have a really good case that, hey, you acted like a reasonably prudent manager would have, so you didn't really violate that standard, but hey, you screwed up over here on the security side, and so we're going to get you over there.
Wow. No.
So that's the consequences. It's primarily rescission. And then if you kind of go a little bit further where it goes to fraud, especially if you're starting to commingle and using some of their money for personal gain or money to try and, maybe fill a gap in another deal you have, if you start mixing and matching funds, then you're starting to look more on the criminal side for sure.
Wow. All right. So let's talk about what are the basics. I mean, what do you need to do? What definitely needs to be buttoned up?
Yeah, well, I think that what we've kind of been talking about is probably the number one thing. I've come up with this framework of all these landmines that people just compliance landmines, right? And I think the number one landmine or the number one issue people have is just not really understanding the answer or having the answer to the critical question which we've been answering, which is, hey, when I'm taking this person's money, am I selling them a security or not? That's like, is this a security or not? Is like the most basic thing, and a lot of people think that. Like my story, hey, it's friends and family only, or it's a small deal. I don't have to worry about securities. Or, hey, no, this is a joint venture. Probably my favorite one. Hey, it's a joint venture, so I don't have to worry about it. Or, oh, it's a promissory note. Yeah, that's not a security. No.
Sure.
All of those are potentially and most likely securities. Anytime you take money from passive investors where the returns are generated by your efforts, meaning you're doing all the work, generating the profits, and you're just giving the profits to the investor, that's a security. It doesn't matter how you structure it. The SEC could not care less what you call it, joint venture, promissory note, this, that, the other. How you structure it, they're going to look straight through the structure, and they're going to ask that question: is the return being generated by your efforts? Is the investor writing you a check and then going home and just collecting the thing? If that's the case, whether it's a promissory note, joint venture, friends and family, it's going to be a security. So that's step one, is just identifying whether it's a security. And I call it a checkpoint. It's like, hey, stop, let's go figure out, is this a security that we have to go comply with all the securities laws, or is it not a security and we've got a good argument? Once you realize that you're selling securities, then you have to either register that security with the SEC, number one, or you have to find an exemption to registration, or it's illegal. I call it the REI framework, right? Register, exemption, or it's illegal, right? We never register because that's going public, IPO. We don't have time for that nonsense. And for real estate investors, we got to close in 45 days, 60 days. Right? We don't have time to go spend a year or two trying to, do this thing, right? And then we don't want to do anything illegal, right? So we obviously want to follow law. So we're always looking for an exemption, right? And that's where you hear things like 506B, 506C, maybe you hear Reg A, or all these like things that you hear. All of those are exemptions, so that we don't have to register. Because if we didn't have the exemption, which is one of the issues, like if you blow one of these exemptions, then you just have a non-exempt offering or non-registered offering. So we want to comply with the exemption so that we don't have to actually file, because again, nobody files. And that's really, at the end of the day, what you end up, from a compliance standpoint, what you end up with is an unregistered offering because you blew the exemption. So for example, if you are posting on social media and advertising your deal and you have an exemption that prohibits you from doing that, like a 506B, then you're no longer able to use 506B as your exemption. Wow. So now you say, okay, well, you got to register it, or you got to find another exemption, right? And if there isn't another exemption, then you have to register it. And most people haven't registered the syndication, so it's an unregistered offering. And that's what triggers the rescission rights. And if it's fraud, then it'll be jail time.
Wow. Interesting. Okay, so we got that part. What's next? What are some?
I mean, let's dive. So just for those who are LPs too, by the way, I want to make sure whether you're an LP or GP, this is kind of important stuff. So luckily, there's a bunch of different exemptions, right? Like I rattled off a few, and there's like 10 more, right? But most of us will use. There's two of them that are by far the most common. That's what's called a 506B exemption and a 506C. Most people use 506B. Right. Okay. And so 506B does allow you to raise an unlimited amount of money. You were talking about, I think, Blackstone earlier on. Blackstone's latest raise, I think the latest fund is over 50 billion. That's a 506B exempt offering, right? If you go look at their Form D, it's 506B. Now they use broker dealers, which is how they kind of are able to do that. But it's a 506B because you can raise unlimited amounts of money. Now we're not going to be raising billions, but we don't have to worry about how much money. We can take non-accredited investors, which is really attractive especially if you're just starting out. So like an accredited investor is a high net worth individual, somebody with over $1 million in net worth, excluding their primary residence, or income of $200,000 the last couple of years and a reasonable expectation of earning 200 or more this year. So 506B allows you to take non-accredited, which is really attractive. So, you're raising money and your Uncle Bob or Aunt Karen or, whatever they may not be, or your buddy from high school, they may not be accredited. You can take up to 35 of those. So that's really cool. But The drawback is you cannot advertise. You cannot generally solicit. You cannot do what's called condition the market even. That's the vague part. So you can't even post stuff that gets people excited about a deal without even talking about the deal specifically. So it gets really tricky and nebulous.
What can you market? It seems like the list of what you can say is a lot shorter than the list of what you can't say.
Official answer, here's the official answer on that, because this is one of our landmines. So my first landmine, I usually say they just don't know the answer to this critical question, right? Is it a security? The second landmine is the social media landmine, because people are posting all the time, that we talked earlier. And the real answer, the official answer that I would give you is, look, if you're doing a 506B, these are private offerings. These are meant to be for people that are in your network already, for people you have pre-existing relationships with that you already know, you know their situation, you know their goals. It's private. You're supposed to pick up the phone and say, hey, Bob, I know you're looking for a deal. I've got a deal. Yeah. Can we get together for coffee? Like, that's what a 506B is meant to do. It's a private offering. It's not meant to be advertised. In fact, you're not allowed to. So if you want to advertise and you're good at social media, or you think you can expand then we have an exemption for that. It's called the 506C exemption. That's the exemption that allows you to go on social media, that allows you to go on podcasts, that allows you to go to meetups, it allows all of these things to do. That's the route you have to take. Now, the challenge is, if you take that route, there's some limitations, right? The first limitation is you could only take accredited investors only. So your buddy from high school and your Uncle Bob, they're not going to be eligible. So that's a big that's a trade-off. Right. But if you're going to be advertising, because that's what you want to do, then 506B is not for you. 506C is for you. And there are actually a couple of other exemptions that you could think about when you're talking about advertising, maybe a Reg A, maybe a Reg CF, although those have some downsides too. So if you want to market and get the word out to people that are outside of your immediate private world, then 506C is the one you should be using. It just limits you to accredited investors only, and it has a requirement for you to verify their status. So you can't just take their word for it. You've got to get, tax returns or a letter from their CPA or something to confirm that they are in fact accredited.
Now, is that the only difference between the B and the C, or is there...
That's the only difference. In fact, if you call me, and again, I don't do this anymore, but you can definitely call me. But we'll talk about maybe our mentorship program. But if you called me earlier and said, hey, I've got a deal in the contract, I'm debating should I do a 506B or a 506C? The two pivot points are going to be, number one, do you want to take non-accrediteds? Because if you want to take non-accrediteds, then I got to go B. And the other pivot point is, do you want to advertise or not? Those two levers will dictate, which exemption you go. If you want to advertise, I got to go C. If you want to take non-accrediteds, I got to go B. If you want to do both, that's where Reg A potentially comes into place. The problem with Reg A, which allows you to advertise and take non-accredited, is it does require some form of registration with the SEC, which means it's a longer process. It's drawn out. It'll take you 6 to 9 months, which usually doesn't work for you. It's way more expensive because now your lawyer has to negotiate with the government's lawyer. And so there's that option. But barring that, if you're just between those two, those are your two pivot points.
Gotcha. Okay. So social media, and then we talked about, is it security or not?
I think, and then the other big landmine that I talk about quite a bit. This is the one I think where most people are really, I think people realize that they don't know what they don't know. That's probably usually their biggest fear. But
sure.
One of the things that I get, there's only two things that got me, I don't want to say cringing. That's maybe a little too excessive, but one of them was joint ventures, which we can talk about in a second. Yeah. But the other one was like, hey, Mauricio, I'm under contract for a deal. I've already got all the money raised. I just need the docs. And I'm just thinking, oh my God, what have you told these people in order to get the commitment? Because you don't just get commitments. That means you have email communication with them. You've probably sent them some underwriting or a business plan, and you're just making offers. And by the way, the SEC regulates sales, but also regulates offers. You've been out there just communicating with no attorney reviewing your materials or putting the proper disclaimers. Hey, this is not an offer. You've just been talking to investors. You've been sending them emails. You've been posting on social media. And then suddenly you've got all these soft commitments. That alone, that one landmine of soft commitments has 100 landmines inside of them, right? What are you sending them really? And so all the communications that you have with your investors prior to the time you actually call your attorney and hire an attorney, those are all landmines just ready to explode in your face.
Yeah. Well, let's talk about the JV and the other one. I feel like I see it all the time is like notes, where people are raising money through notes, and it's and I think a one-off note works, right? I mean, if you're putting somebody on a first position mortgage on a fix and flip loan or something like that.
Yeah, that might work. Yeah. So
but when you start bringing them together,
yeah, well,
that's just,
Notes,
Right.
honestly, notes is a tough one. Notes is probably I did a post today because I did a whole session in my coaching program, and I did a whole thing on notes. And it's probably the most difficult thing for me to explain. Like securities laws, I'm like a library. Everything's in the back of my mind. But notes is so tough because there is no black and white. There's all these factors, and they've got you've got a family resemblance test and a thing. But if your note, so first of all, let me just backtrack on the note, and I'll give you a resource because what I ended up doing is doing all this research on the notes. I was going to do an ebook about it, and then I just turned it into a chapter in my future book. I don't even know. I don't have a book yet, but I'm like, this is a chapter, and at some point, I'm just going to plug it in. So if you're interested in that, I'll tell you how to get the chapter of the book on promissory notes. But if you look at the definition of a security, right, the first word in there is a note. Like a security is a note, comma,
okay.
a this, a that, a the other, right?
Yeah.
So the presumption is it is a security.
Wow.
That's the starting point. Now, there are ways to rebut that presumption to say, no, it's really more, it's there to facilitate a transaction. It's commercial paper. Like, for example, Peter, if you owed me a bunch of money, or maybe I owe you a bunch of money, let's say I owe you a bunch of money, and you're like, hey, you know what? You owe me a lot now. Let's document this. Let's go do a promissory note to sort of, document thing. That's not going to be a security. If you tie it to the property, like if the outcome is an investment base. So if you say, look, I'm going to lend you money, and I'm going to buy this property, and then when the property sells, I'll pay you back, and I'll give you a 20% or some cut of it or whatever. That's a security no matter what.
Sure.
Because it's tied like that. Now, if it looks more like a private money loan where it's it's one note, you secure it in first position, like a hard money line, you have principal and interest, or maybe interest only, even interest only paid monthly. So it looks like a loan. Then, okay, now we're starting to argue maybe that looks more like a hard money loan, traditional loan, private money loan. That's fine. If it's one, to your point, if you start fractionalizing that note or having more
aggregating,
people, that's an investment contract. So you're already, if you have more than one, but if you have one investor, here's a safe way to do it. And then you just got to read the chapter because it's too complicated, or it would take an hour to do it. Here's the safest way to do a note. So if this is what you've got, I'm good with it. But it's not guaranteed, but I'm good with it. Number one, it's one person, one note.
Yeah.
It's secured in first position.
Yeah.
And it's a interest. There's an interest on it, like a market rate interest, 12%, 10%, whatever, principal and interest, or maybe even interest only. If that's what you got, we're good. But if you're starting to be like, I'll pay you back, and there's no principal and interest, and I'll pay you back in 3 years when the property sells, and I'll also give you a 10% kicker or a profit share from that. Like profit share, forget it. Like once you're profit sharing on that, that's going to be an investment contract, or it's going to be a security.
Yeah. Wow.
So securities are a mess. Not easy. I would encourage you guys, anytime you're doing a security, just don't assume that you're good. Go talk to an attorney. If you're in my program, you just come to the call and you ask me, but go talk to an attorney and say, hey, I'm thinking about doing this as a note. Am I good? Just double check. Don't assume you're good. The other one's a joint venture.
Yeah,
so that's the other
crazy
part. The joint venture one, people would call me and say, hey, Mauricio, this is kind of a small deal, just friends and family, kind of like my other story. It's a small deal, friends and family. I think I'm just going to do this one as a joint venture. And I just kind of smile. And I said, look, whether this is a joint venture or a securities offering, you don't get to make that decision. The SEC will make the decision. The regulators will make the decision based on how you've structured it. I didn't do joint ventures, but I had a great attorney, wasn't a securities attorney. He was a joint, basically would do joint ventures, but he knew enough about securities law that once I sent him over there, because they would talk to me and it's like, oh no, this, it's a joint venture. I'm like, okay, that sounds like a joint venture. I'd send them to this attorney and he would call me back and say, this sounds like a securities offering. Like, that's why I like sending it to him, because then he'd send it back. But in order for it to be a true joint venture, again, calling it a joint venture isn't going to cut it, right? The structure is what matters. Yeah. So it has to be the opposite of a security. Like it can't be a security, right? And if you remember the definition of our security at the beginning of the show, anytime you take money from investors where the returns are generated by your efforts, that's a security. So a joint venture is a investment or a partnership where the returns are generated by everyone's efforts.
Yeah.
All 4, 5, 6 partners, don't call them investors, not investors, they're your partners, your business partners. They all have a specialty. They're all going to roll up their sleeves. They're all going to contribute to the generation of the return. They're all going to be, unless there's some wacky reason, they're all going to be getting distributed, proportionally. Like if I put in 10% of the money, I should get 10% of the profits. If I put in 50% of the money, I'm going to put 50% of the profits. When you start seeing structures where there's one ringleader, right? The more ringleader, the more it looks like a security, and especially if there's something like an equity, like a profit, not a profit share, a carried interest, right? Sweat equity or a pref. Like if you start looking at prefs and sweat equity, carried it, those are securities languages. A joint venture would be literally less than 5 people. You can't, if you have more, it's just very difficult to show that everybody's actively involved.
Sure.
And the more concentrated the power on one person, the more likely it looks like a security. Ideally, all 4 of you or 3 of you are co-managing the deal. You're co-managers of the LLC. Every decision gets run by all 3 of you or all 4 of you. And you certainly don't have 8, 9, 10, 11 partners. That's not going to work.
Yeah. All right. Well, let's talk about this one. This is one I've been seeing a lot of recently in the last couple of years. It's the fund of funds and the capital.
Oh, yeah, that's another landmine. Yeah, that's another huge landmine, right?
Yeah.
So that's another huge landmine. So what's happened in the last couple of years is that people were having a hard time raising capital. And so they were starting to come up with this idea of like, let's have people bring in capital for us and we'll just make them a co-GP in the deal. And that somehow, again, big mistake, landmine number 5 or whatever. That's not enough, right? Just because you give them a co-GP, just because they're part of the co-GP doesn't get you out of jail. They have to do things, right? So if their primary role in the co-GP is just to bring in the money, you're going to be screwed. So what people are starting to do is switch it a little bit and say, well, instead of me coming in as a co-GP, I'll go raise my own fund. I'm, whoever that person is really good at raising money. So they'll create their own fund, a compliant fund. They'll hire an attorney. They'll do their own PPM. They'll do their own thing. They'll raise money into their LLC. Great. Now I have $1 million or $5 million in it. And then they'll go out and invest as a limited partner in all of these other deals. Totally fine. No issues there. However, we move into another area of regulations when we do that, because you and I are, most of my clients were and are real estate investors, right? And when you invest in real estate, you don't need a specific license to do that, right? You don't need to have a real estate license or anything. You want to go buy a piece of property, go buy a piece of property, right? So when you're syndicating real estate, there's you have to worry about the regulations about raising the money, 506B, 506C, but there's no other licensing that I need when I invest in real estate. But with a fund of funds, you're not investing in real estate. You're doing what? You're investing in shares in somebody else's company, or really membership units in an LLC. But basically, think about it, you're buying shares. You're buying securities. And that opens you up to all these other regulations that a lot of people don't even know about them. They don't think about them, and they don't get proper advice sometimes, or they just do it. And so the big ones are, there's an Investment Companies Act that, again, I don't worry about when it's real estate, but when I'm selling securities, I got to make sure that I comply with the Investment Companies Act. That one's easy. As long as I have less than 100 members in my fund, most people will get covered under a 3C1 exemption. So less than 100 members, because you count, but less than 100 members, you're good. So Investment Companies Act, less concerned about it, easy to get around. The big one is the investment advisory rules, because what happens is the securities laws will see you as the fund manager. You're advising your fund as to the purchase of securities. So that makes you an investment advisor. And then the question becomes, do you need to register as an investment advisor, which you really don't want to do, or is there an exemption? And most of the time you're looking at your state. So whatever state you're in will have the terms of the exemption, and some of them are easy. Some of them don't care. Florida comes to mind. Like, as long as you're not doing 15 of these fund of funds, you're good, right? And you don't hold yourself as an investment, but you're good. If you're in Texas, they have a limitation of, hey, you're exempt, but you've got to limit your investors to accrediteds only, no matter what exemption you're using, and you've got to file a form. Right? Not too bad. Then there are other states which are like, oh crap, I've got to limit my investors, not to accredited investor, I got to limit them to qualified clients, which is a $2 million number, 2.1, it's adjusted inflation. That kills most people. Like, if every investor has to have at least 2.1, 2.2 million in net worth, that's problematic. And then the last one is, there's some states that don't have an exemption, like Hawaii. So if you're in Hawaii and you want to set up a fund of funds, you just have to register as an investment advisor, because they don't have an exemption. So whether you exempt or not, the main point I wanted to emphasize is you have to look at that. So you have to be working with your securities attorney to say, hey, what state are you in? What does the exemption say? Do I qualify for the exemption? And you have to worry about that. And then the other one I worry about quite a bit, there was a recent case that came out that kind of illustrated this point, is, look, if you're just raising money for one particular operator and you've got the smoke and mirrors, I've got a fund. But at the end of the day, what you're doing is you're just raising money for your investors and giving it to somebody else. That looks like you're a broker dealer. It looks like you're just facilitating a securities transaction without really adding any additional value in it. So you just got to be really careful there. You've got to make sure you're adding value. You've got to be getting paid, not for raising the money for the operator, but for helping doing the due diligence and vetting the sponsor and vetting the underwriting and doing all this work. Because the biggest concern most people miss is that if the underlying deal that the fund invests in goes south, you're going to get dragged down with it, because they're going to nail you, because obviously they've lost all the investors' money. You're one of the investors, your fund.
Sure.
You're going to lose all your money. So you've lost all your investors' monies, and the investors will come after you and say, look, you didn't do proper due diligence.
Sure.
Because the level of due diligence, we just did a post about this a couple of days ago, the level of due diligence that these fund managers do not rise to the level of what real due diligence is. Like if you're a real investment advisor or a broker dealer or a family office, you're going to be spending like 50 grand on due diligence, right? It's some serious due diligence, because you've got your investors. Like if you're an investment advisor and you've got clients and you're managing their money, you're not just going to be like, oh, Peter, that sounds like a good deal, Peter. Let me look at your PP and let me look at your dogs. Yeah, let's put some money into it. No. They're going to do a deep dive. They're going to fly down to your office. They're going to interview you. They're going to check out your operations. They're going to do a deep dive so that if it goes south, hey, I did my due diligence. Everything I looked, checked out. I acted like a reasonable fund manager. Yes, it didn't work out, but there was nothing I could have done to uncover, there was no indication. Let's say somebody just flees with the money and you didn't realize that, hey, they've got a background. You can show the due diligence. That's a big issue on the fund of funds. But the big one is this additional compliance that kicks in because you're investing in securities as opposed to investing in real estate.
Well, you mentioned it too, the co-GP thing. Like I have a brand, and a lot of what I talk about is raising capital, but it's always been for my own funds. You know what I mean? And the places I worked and all. So people will come to me all the time, and it's like, well, can you raise money? Can you if you bring money into this deal?
Yeah.
I'll give you X amount of the GP. And it's like, it doesn't work. I was telling them it doesn't work that way, but they just don't see. Understand. It's unbelievable.
I'm going to start doing some content about it. Yeah, that happens all the time. So it's like calling yourself a capital raiser. I think you're already, I don't like that term. I've used it more now because people identify it's like a vernacular, but at the end of the day, if you're calling yourself a capital raiser and you don't have a license, you're just asking for problems, because just like a law, you can't practice law without a law license. You can't practice medicine without a medical license. It's almost like arguing. Here's the analogy I've come up with right lately. I say, look, you're somehow involved in some kind of, maybe it's something in the medical thing. Maybe you're talking about some natural cures or whatever. And they're like, hey, you need a license. You're not a doctor. You need a license. Like, no, I'm not a doctor. I'm not practicing medicine. But then you call yourself a doctor. Yeah. It's like, okay, well, dude, like if you're going to call yourself a doctor, then you're really going to have a hard time arguing that you don't need a medical license or you're not practicing medicine. It's the same thing with capital raising. Like you generally have to have a license unless there's an exemption, and there's only one exemption that works for us, and most people don't fit into that. So calling yourself a capital raiser, I'd be super, if you like Peter, you are an operator, like you do raise capital, but that's one of the many functions that you do. You then acquire, you're underwriting, you're doing due diligence, you're finding a property, you're getting into contract, you're talking to lawyers, you're asset managing it, you're doing the business plan. I know you work with a lot of sort of, let's call it nicely, dilapidated things. Like you're really adding a lot of value, increasing the rent. Like you're doing so much work. Capital raising is a part of it, but it's not the primary role that you're doing. Exactly. And a lot of these co-GPs and a lot of the fund of funds, their primary role is raising money. And if on top of that, you're tying the compensation to how much you raise, that's transaction-based compensation. That's the hallmark of broker-dealer activity.
Yeah, exactly. And that's where I always hear, where it's just like, everything you just said. And then it's like, well, you're only getting that percentage of the co-GP or something like that if you bring X amount of dollars in. So it's just right there, you're tying it right.
And somebody sent me another example. The other thing you've got to be super aware of is that all of those texts, all of those emails, all those DMs that have all these offers, or sometimes I see spreadsheets that say, oh, look, capital raising, sell, that's not privileged. So if it ever becomes an issue, the SEC or the regulators are going to be able to, subpoena all those documents, and you're saying, no, I wasn't brought in to raise capital. And then be like, well, here are all your messages, your emails, your texts, your DMs that clearly show that you're offering to bring in $1 million in exchange, and you're negotiating how much percentage you're going to get. Wow. You're going to be dead in the water. So just keep that in mind too. Those are not privileged communications, unless of course you're doing it through an attorney. Yeah. Wow. That's amazing. Great advice. Anything we missed? I mean, I feel like we've covered so many topics. Any other on the landmine side, or, I mean, it's just, this is I mean, the entity, maybe one of the other landmines is folks would come to me and they already kind of set up the entities themselves. They just don't realize how to set up entities, where to set them up. And, that's another
SPVs. I feel like that's one you hear thrown around a lot, and I feel like people think that they don't fall under certain securities or things like that, but it's really not any different than anything else, right? At the end of the day.
Yeah, people are using the term SPV. I don't like the term too much, but what they're using it is actually, the way I've seen it done is in the context of a fund of funds. And so a fund of funds, even the word in it is plural, funds. The idea is that you generally would raise money into your fund and then allocate those into multiple different funds.
Yeah.
Gives you some diversity. And then you're really clearly you're Warren Buffett. You're allocating capital to different deals, you're vetting different sponsors, and that's what you're getting paid for.
Yeah.
They're calling SPVs what I call, which I think is what it really is a feeder fund.
Yeah.
And a feeder fund has legitimate roles, right? Like, for example,
Sure.
Ray Dalio, for example, is one of probably the more popular, well-known. He has a fund, right? He's retired now, but let's say he had a Bridgewater fund number 7 or whatever. His minimum investment might be $5 million.
Yeah.
And so it's like, even if you're a high net worth individual, you don't have $5 million. And so feeder funds like Sequoia and all these other funds will get created so that they can put in $1 million or maybe $500,000 or $100,000 into the fund that will then feed into the main one, right? But you're adding value. Otherwise, I couldn't get into the main one. Or maybe there's some other benefits that you're going to get. So they have their place. But if you're just, and by the way, most of those have registered investment advisors as, in that project.
I would think, yeah.
Yeah, all those definitely have. Now, again, in our world, we have to look at it. I don't think you have to, most of the time we don't register. We just make sure we find the exemption. But most of them don't do that. Like it's like, what's the benefit of me investing in your feeder fund versus just investing directly into the deal? You've got to be able to show what you're saying. Now, I think the easiest one that most people say is, I'm doing the due diligence, I'm vetting the sponsor, I'm flying down, which I don't have time for. They're flying down to meet with the sponsor and interviewing the team and figuring out their processes. I'm walking the units. I'm doing my own due diligence of the property. And then I come back and say, yeah, I really like this deal. Let's put money into it. Okay, there's a value there. That's what you really have to focus on. The other thing you typically will do if you're a fund of funds manager is you will negotiate better terms, right? Because you're coming in with $1 million. I don't want your freaking 70-30 split. I want an 80-20 split. I want 80%, not 70%. I don't want you to take a 2% asset management fee. I want you to take a 1% asset management fee. So all of those negotiation is what really generates more revenue to my fund, which I can then reward my investors. So in a perfect world, the investors are actually getting more money by coming in through me than if they went directly, because I'm negotiating all the stuff. I might even negotiate a seat at the table, and there's an advisory role. So again, the interest of my investors are taken care of, and I can report back to the investors, hey, I'm in these meetings, this is what's going on. So you got to show stuff like that. Most people, not most, I shouldn't say most, a lot of folks are just literally, oh, I know a couple people, I can go raise $500,000 for $1 million. And they just take the underwriting from the underlying sponsor. They use the underlying PPM, and it's like, yeah, let's just match you. And that's where the broker dealer issues come in.
Yeah, makes sense. Well, let me ask you this then. So you're somebody, you see a lot of these deals and years and years of this. What do you like? What do you like right now? What are you investing in? What has you interested in this market, in this world today?
It's interesting. We're recording this on a week that is very tumultuous already. This is the week that tariffs came out. And,
right.
I have a podcast called Drunk Real Estate, which is kind of a fun one, just a fun podcast, but if you want to check it out. But one of my co-hosts is Jay Scott, kind of well-known in the bigger podcast world. He's actually calling for tomorrow as D-Day, because tomorrow payrolls come out, and the government's been laying off a lot of jobs, and it's like, and it's already happening. And so, I'm very, very cautious. I guess all I'm saying, I'm very, very cautious. We've talked about it on the show a lot. I think a recession's on the horizon. So I'm not actually acquiring anything too risky right now. I'm really focusing on gold, to be honest. I'm a precious metals guy. So that's more because I'm conservative. I generally love real estate, and that's where I would go. I like multifamily. I like mobile home parks a lot. That's that's kind of my
one right now.
So and because I'm a high earner, oil and gas is also attractive, because oil and gas allows you to offset the losses against your active income. So if you're a W-2 earner, or you've got some active stuff, the nice thing about real estate is you can offset passive income with passive losses with passive income. Yeah. But if you don't have a lot of passive income and you just make a lot of, because you're busy doing, you're a doctor, or lawyer, or just somebody makes a lot of money, being able to offset your active income with investments in certain asset classes, that's attractive too. But right now, man, I'm hatching down. I got a high cash position, and just being pretty conservative. But
wait and see.
But it's coming. It's hopefully it's coming. We really need. Most of my clients are multifamily. We really need the last things to just shake. There's a lot of lenders are kicking the thing down the can. It was basically, I think the last motto I heard was like, survive till 25. Well, we're already here at 25. Now I'm hearing persist until 26. Yeah. Lenders are still pretty slow. They don't want to just foreclose and take it all back. They're working with lenders. They're extending the loans last year. Now those loans are coming due. And so we just need those loans to clear, because once those loans clear, people, look, they're going to have to sell at a loss. Investors are going to lose their money, but we need to get that cleared so we can start the new run. And once that happens, whether that's this year or next year, you're going to see a nice, and especially if we can get the recession out of the way too. That's another thing. The recession is necessary. We need to get it done and over with and start a new cycle. And when that cycle happens, then it's going to be fun.
Awesome. Well, Mauricio, this has been an amazing conversation. I could talk to you all day. You are a wealth of knowledge. So thank you so much for being here. For people that want to learn more about you, get into your world and you get your content, learn more about your mastermind and all, how could they do that?
Hey, if you want to copy that promissory note chapter, just if you go to askmauricio.com, just mention this podcast and you want the thing, I'll send you that. And if you're interested in the coaching program, you can just go to coachingwithmauricio.com.
Great. Well, Mauricio, thank you so much.
Thank you for having me, Peter. Appreciate it.